Good morning. Oh, well, actually, good afternoon, everyone. And thank you for joining our Thursday morning webinar. Sarah and I are going to be talking about how to get the most out of your case. Sarah is here. I've said this already for those of you who just joined. We just can't see her. She has still graced us with her presence, but we don't know what she's doing on the screen because we can't see her. But she is here, and she hopefully you can all of you can hear her. We are going to be tackling this in several parts. I'm going to hand over to Sarah first to talk about funding.
Yeah, thanks, Dom. Just to remind everyone, if you've got things you want to chat about, fear of heights, fear of depths, where we went on our holidays, skydiving, then put them in the chat. If you've got questions for us, then put them in the Q&A. And we say this every single time, but every single time somebody puts a question in the chat, which is fine. It's just that it's harder for us to pick it up if there's lots of chatting going on. So if you've got questions, then do raise them as we go through. And we'll try and answer them as we go through. You can ask questions anonymously if you like, or if you prefer not to, absolutely fine. We're all friends here. We usually find in some of these webinars that somebody asks a question that we don't know the answer to, but somebody else participating will know the answer. So feel free to jump in if you know the answer to the questions, because it saves our blushes if we don't. The webinar is being recorded, and a link will be made available to you afterwards, as well as slides. It will also be on our YouTube channel as well, with all the other historical webinars that we've done. So for that reason, if you're asking a question that you are not sure that you want everyone else to know that you yourself have asked, then it's best to anonymise, just to cover those points. Right, so we're going to talk about how to get the most out of your case today. We've already spoken about how to get the most out of your clients, how to get the most out of your barrister, and how to get the most out of your experts. But today, just drawing together a few of those threads and a few other little bits and pieces, anecdotes about the things that we've experienced, pet peeves that members of chambers have come across, learning experiences that we've had from dealing with other cases and dealing with a range of solicitors, and of course, doing both claimant and defendant work. So just running through how to deal with case, how to plan strategy, what to think about and when to think about it. And believe it or not, a lot of these problems come up time and time again. So you find, for example, with funding, which I'm going to talk about in a moment, that you enter into a conditional fee agreement when actually you didn't need to because there was household insurance available, and that creates something of a pickle. So just worth running through as a checklist some of these basic points. The talk today is going to range from quite basic points to quite advanced points, and depending on what the questions that we're asked and the answers that we have to give. But just some quirky stuff, like my great love for things like notices to omit facts, and Connor Kennedy's great love for Part 18 questions, for example, and just a few bits and pieces. So first of all, funding. That's the first question you need to be asking yourself as someone walks through the door wanting your assistance. How is the client going to fund the case? In the case of both claimants and defendants, you may find that there is relevant insurance, and it is always worth checking, for example, motor, travel, household and other insurance. So we get quite a lot of skiing cases, and quite often the defence of those cases is covered by insurance, whether it be travel insurance or quite often household insurance, actually. So always worth checking those. Some motor insurance policies cover some really quirky things in consequence of a European case called the NUC. So it may not be completely obvious to you that things like mobility scooters are going to be covered. They may well be covered under one or more insurance policy that either the claimant or defendant, your client, may have. It may also be that your client is a member of a union or professional organisation, and that they may well provide funding for legal claims. It'll probably be panel funding, but you can usually get an exemption to that if you have the relevant expertise, and if you kick off a claim, they'll usually allow you to continue with it. Of course, conditional fee agreements, and then of course private funding. What I would say about private funding is that I've had a number of clients who have said to me in the past, I'm very happy to pay for this privately. You know, I'm a wealthy individual. I can fund this privately, and there's no need to worry about it. who then get halfway through the litigation and say, well, now that I'm 50,000, 100,000 pounds down, I don't feel like quite such a wealthy individual. And I slightly wish that I hadn't embarked on this privately funded. You need to be realistic with those privately funded cases as regards how much the claim is going to cost. And that is going to involve consideration of the question of costing. So when you're looking at funding, it's really important to consider with the client, how are they going to fund this and how much is it going to cost, which is the next question I'm going to deal with. So taking a realistic view of how much a claim is going to cost, either to bring or to defend, is going to involve a front-loaded looking at your experience in similar cases. Remember to include disbursements and VAT. I've seen quotes given to clients which don't include VAT. And if the client's not VAT registered, that is not enormously helpful because it adds an extra 20% on. So it is a huge difference to the clients. So remember to include disbursements and VAT, and that includes court fees, which are pretty chunky now, unless, of course, they can get an exemption. So just taking a holistic approach, how much is it going to cost? Clients not that interested in the breakdown, but they are interested in the bill at the end of the day. Be realistic about that. There will always be known unknowns and unknown unknowns. There may be applications that you haven't foreseen. There may be speed bumps along the way. There may be diversions along the way, things like applications for disclosure, and Dom's going to talk about disclosure in a bit. You need to factor those in when you've got a privately funded client. And be realistic. The client needs a best case, worst case, realistic scenario range. And of course, over the course of the lifetime of the litigation, the costs of it may go up, and they need to know that as well. Of course, these are all things that you're professionally obliged to do in any event. We sometimes see that those obligations are not met. Keep the client informed of changes immediately. That may be a change in the availability of funding. It may be a good thing or a bad thing, but they need to be informed. They need to know of the developments that are going on. And that goes not just for costing, but for everything else as you go along. Turning now to something which is close to my heart and Dom's, because we do cross-border work. I won't spend too long on it today because it's not relevant to everyone, but consider jurisdiction very early, because you may find that you've got, for example, a foreign defendant, or you may find you've got a foreign accident, or you may have a foreign claimant. And in any case, it involves an element which is foreign, by which I mean not England and Wales, could be Northern Irish, could be Scottish, because those are different jurisdictions. Are the courts of England and Wales going to accept jurisdiction? You need to think about that right at the beginning, because which jurisdiction you're in is going to affect costing, it's going to affect funding, and it's going to affect whether or not there's actually a viable claim which is economical to bring, or whether or not it's economical to defend. So consider jurisdiction early on. Do you want the courts of England and Wales to accept jurisdiction? This is something that I'm going to come back to in a moment on applicable law. It may be that England and Wales is the right jurisdiction, but you don't want the courts of England and Wales to have jurisdiction. So it may be in your interests to try and get the courts of some other nation to accept jurisdiction. Now, jurisdiction isn't going to affect limitation, but applicable law is, and I'll come on to it in just a moment, Anne. So you may, for tactical reasons, particularly if you're a defendant and you see a claim in the offing, and if you're talking about a largish claim, which is being brought in England and Wales, or that's the proposal, you may want to torpedo jurisdiction, which means that you're bringing a claim for declaratory relief. So it's a sort of anti-suit type affair, where you are asking the courts of, say, France, to declare that you are not liable for the claim. And that way the courts of France are going to be seized of that claim before the courts of England and Wales. So you might want to just think about tactically, strategically, which courts you want the claim to run in, both when you're acting for claimants and for defendants. There are obvious advantages in relation to costs in bringing the claim in the courts of England and Wales, because cost rules are more favourable here. there may be logistical advantages to bringing the claim here, or there may be logistical advantages to bringing the claim elsewhere. So, for example, I'm just doing at the moment a Belgian case, or a case that involves Belgian jurisdiction, or the possibility of that. And some of the police courts in Belgium can run the case very cheaply and quickly, so we're told. And some of the appellate courts in Belgium, it takes much longer, it's much more expensive. So you need to think about what the advantages and disadvantages are of having jurisdiction in England and Wales. Interesting, I just did a case called Cleafer and Slater, in which the fact that the claim had been run in accordance with the pre-action protocol here, and costs have been incurred here, was a factor that the court took into account in looking at whether or not the courts of England and Wales should have jurisdiction over the courts of France. It was a French accident, French defendant, French accident, French claimant, English defendant. The French claimant had chosen to bring their claim in England against the English defendants because they wanted the cost rules to apply and because they wanted ease of enforcement. And those were legitimate juridical advantages, so the court held, which meant that the claims stayed in the courts of England and Wales and didn't go to France, which I felt was probably the more obvious forum for the claim because the accident happened there, the claimant was there, claimant's witnesses were there, the experts were there, and French law was going to apply. Now, in relation to limitation, as Anne asked, that's going to depend on applicable law, which is the next thing to consider. And applicable law feeds into the jurisdictional argument as well, because in order to bring the claim within the jurisdiction of England and Wales, it's going to be helpful if the applicable law is the law of England and Wales. So one of the things to ask yourself about very, very early on, pretty much at the beginning of any claim, is what law is going to govern that claim. Now that we've Brexited, the rules on jurisdiction are different. They're the common law rules on jurisdiction, but the rules on applicable law remain the same. So the rules of Rome 1 and Rome 2 remain in force in relation to contract and tort law. So the applicable law is going to govern limitation, liability, and quantum, but not procedure or recoverability of costs. So if you've got a claim that's being brought in the English courts, the CPR is going to apply, all the pre-action protocols and so on apply, and you get English recoverability of costs, which is a really big advantage in most cases. Maybe not in America. But the applicable law does govern limitation. So if you've got, say, a claim from the Dominican Republic and the applicable law is that of the Dominican Republic, some of their limitation periods are 6 months. So it's really obvious why you need to think about applicable law right at the beginning of the claim. Because if you think about it 6 months in, you'll have missed limitation in some countries. That's very unusual, but it can happen. And quite a lot of countries have 1 and 2 year limitation periods, so it's worth thinking about. Now, I had a case recently where the claimant was arguing for French applicable law and the defendant was asking for English applicable law on the pleadings. But actually, it was in the claimant's favour for English law to apply and in the defendant's favour for French law to apply. So we found ourselves then at the hearing, the barristers reversed the position. So I said, I was from the defendant, and I was saying, well, the claimant was asking for French law, therefore they should be bound by that. It should be that that applies. And the claimant's barrister was saying, well, no, the defendant was saying that it ought to be English law, and we're going to get lots more damages under English law than we would under French law. So it should be English law that applies. And that happens a lot, that litigators haven't considered which law favours them. They've just said, well, I think the accident happened in France and therefore it ought to be a French applicable law. Now, you might not want that. So you might want to be looking at, are both parties English, for example, in which case English applicable law is going to apply. But look at which jurisdiction favours you and which applicable law favours you at the very threshold of the claim, because you may find that actually the claim is not worth bringing because it can't be brought within this jurisdiction and because it's not economical to do abroad. Or, for example, it's not economical because the applicable law provides for such a very low recoverability of damages. So it's definitely worth looking at that at the beginning. And then as feeds into that, you need to think about what the client's aims are. What are they looking to do and looking to achieve? And that's where Dom takes over.
Thanks, Sarah. So yes, dealing with that, it's always worth understanding what your client wants to actually achieve from the litigation. Often that depends on the circumstances leading them to bring or defend a claim and the sort of claim that it is. For example, I tend to find when I act in an inquest, for example, that families want lessons to be learned. And so they want to make sure that what happens and happened to their loved one doesn't ever happen again. And that's often their principal aim when one goes to an inquest. But of course, in a clinical negligence claim, you might find a claimant actually really wants an apology from a trust or a healthcare institution. And it's worth exploring on both sides in that sort of claim. Firstly, if that's something a claimant wants, and if you're for a defendant, is that something your client is actually willing to give? Because if you can sort that out, for example, if it's such a fundamental part, and so I've attended mediations before where there's been a real point made that the claimant really wants an apology, see if that's something, if that is going to make it easier for you to resolve the claim. See if that's something that your client, if you are for a defendant, is willing to step forward and give. Other claimants obviously are wishing for monetary compensation or to just simply bring a claim as a matter of principle because they feel wronged about what happened to them. And if you're representing a defendant, it may well be that your client doesn't want to have their name dragged through the mud or in court, or wants to put a defence forward that you don't think is really going to succeed. And I've had a number of cases where the client knows the chances of success are slim, but out of principle, they just want to have their day in court. And sometimes that's the case. I think understanding where your client stands helps you to build a better relationship with your client because you understand exactly what you need to advise your client of and the plan of action that you need to take going forward. And it also helps you to think about the risks and the benefits of any approach that you take so the client's fully aware from the get-go. If you are for a defendant, you might want to think about it, whether a confidentiality clause would assist in reaching a compromise. And indeed, you could think about this if you're for a claimant, if it's something that the defendant seems to be quite stuck on. It may allow the claim to be settled or resolved in some way without any adverse publicity, and that's sometimes something that a defendant really wants to achieve. In terms of what the client needs to hear, obviously be frank about the potential risks and benefits of litigation, and I can't stress that enough. I act for both claimants and defendants, and from my own perspective, when we talk about risks, I've had cases where I've just been instructed to go to a trial and represent someone, and a client's facing allegations of fundamental dishonesty, and contrary to what I've been told, it becomes quite apparent that they aren't quite aware of the seriousness of that finding and the implications, or when it was raised, and nor do they seem to understand how that could affect any CFA agreement. And those are key things that you would have to, of course, let someone know about if fundamental dishonesty is on the table, because of course we know it's something that's raised more and more in particularly personal injury work. It's just something we encounter all the time now. On the other hand, I've had conversations with defendant clients about the risks of failing to beat multiple Part 36 offers that have been put forward by the other side. Your client has to know about these risks, as I'm sure you all know, because it helps them make decisions. And it's not, of course, our decision at all that we need to make. It's one for them. And your client might have an opinion, want to do something that's entirely opposite to the advice that you give. But the better informed, of course, they are, the easier it is for them to make an informed decision. We've put on the slide as well about being consistent with the advice that you give and that between you and counsel. I think it's really helpful to just sometimes pick up the phone to us and just ensure that we're all on the same page. Sometimes we have differences of opinion, as is always the way in any case, as to what will work and what won't. But you want to have those discussions before you go into a conference with the client, because it should be straightforward to you and something that you all are aware of. But it does happen sometimes where differences of opinion arise in the course of a conference, and a client might get confused as to why one person's saying one thing and another is saying another. But also in terms of what changes in the case, sometimes, as we know, and we'll come on to this in a bit more detail, things do change as we go along, which may affect prospects of success. For example, if you've got a claimant who's claiming for a food poisoning claim, and social media evidence is disclosed and it shows them on a rodeo when they say they were ill in bed, you might need to have a conversation with them pretty quickly about that, because again, that changes your strategy going forward and helps you reassess the risks at that point of the litigation, so that the client is fully informed. So as I've mentioned already, I've touched upon this, the client has to be informed immediately of any important developments, including offers, any allegations of dishonesty on their part as well. But in terms of the most important slide of the talk, we think it's this. If you've made a mistake, just own up to it, tell your supervisor, your client, and together we will fix it. Now, we are all human. We all make mistakes. As much as we try and avoid it and be as diligent as possible, it sometimes happens. That's life. But where it does happen, it's so important to be transparent about it and upfront. From my own experience, I had a case some time ago where I had prepared a particulars of claim, and I was later asked to review defences that had come in. And it then became apparent that the defence was responding to something that I hadn't drafted, and essentially my particulars had been changed without knowing about it, because there were some problems beforehand with issuing that I wasn't aware of. It's things like that you've got to just communicate to us before doing anything, because we'll often be able to help you figure out the best way of dealing with it. Sometimes I get emails, say, which I've drafted something and I haven't had emails in a case for a while. And then all of a sudden I get an email some months later saying everything that could have gone wrong has gone wrong, help. And at that point, because I haven't been informed before of all of the things that are potentially going wrong, sometimes in certain situations it might be a bit late to fix something, whereas if I'd known before, I could have stepped in. That's where I think it's so important just to tell us, and so we can get on the phone and you know, likewise we will do the same to you. But it just helps if from everyone's perspective, so that we can all get on the same page and fix it together if we don't know about it. Sorry, Sarah.
Sorry, I just wanted to say, I also think it's really important you don't feel alone.
Yeah, absolutely.
We've all done things that haven't been splendidly tip-top 100% what we want them to be. I mean, I wouldn't say that I've made any mistakes myself, but I know of other people who may have done. You know, we have all done things that have turned out to be bad ideas, or just had a brainstorm and done something wrong. I mean, I think you know about this, Dom, but one time when I was very junior, I went along to court, and I was for, let's say I was for Smith versus Jones. And I went through the waiting room shouting, oh, Smith versus Jones, Smith versus Jones. And Mrs. Jones came up to me and we had a conference together. And it was only when I was about an hour away through the conference that I realised that I was acting for her opponent. I'd actually forgotten who I was acting for, because I always acted for defendants. And on that occasion, I was acting for a claimant. And that is a pretty egregious mistake. It was rescued as it happened because my opponent had got on the wrong train to the wrong court. So we were, you know, neither of us were in a position to proceed, and the claim didn't proceed on that day. But it was really embarrassing. And I just wanted a hole in the ground to open up and swallow me. So we have all been there. Not everyone's done something quite as bad as that, but, you know, we've all been there. And, you know, no one's going to be cross and shout at you, or if they are, you're really, you know, you're in the wrong job, because your supervisor should be supporting you and your barrister should be supporting you, because we all understand. Obviously, Dom is yet to make a mistake of that magnitude, but, you know, eventually we all get sued as well, is the other thing. I remember quite early on when I was at 1 Chancery Lane, I was sued by an irate litigant in person on the other side who was very cross about something. And I was sued alongside about 20 or 30 other people, including Her Majesty the Queen, which is always a good sign that, you know, you're on the side of the angels. But Sean Ross, who was our head of chambers at the time, came into my room, and he came and sat down and he said, you know, we've all been sued. Don't worry about it. And it was really reassuring. So, you know, I know we've said this before in other talks, but it cannot be repeated enough. But everyone makes mistakes. Things go wrong for everyone. Sorry, that was my 2 penneth worth.
No, it's great. And it's so true. I think it's just communicating, isn't it? Rather than burying your head in the sand. And I know, you know, whatever kind of walk of life or any instance, you tend to think, how do I best deal with this? And you might have messed up doing something that's not work related and think, actually, I just don't want to tell anyone about it. But I think it goes without saying, if it's work related or not, it doesn't matter. Just speak out about it and don't feel alone, because we all will be there at some point, if we haven't already, and it's better for us to try and help and resolve the situation than not. I won't spend too long on disclosure, as I'm sure that you all know what's required under CPR Part 31 in terms of standard disclosure and the like. But try and make sure as best as you can that you've seen everything. We all have days where it may be that in a conference that someone comes out with something and says about a document that none of you knew existed. I had that very recently, that one of my witnesses said that they'd sent a letter which no one knew about and we'd never been made aware of, and we all were going on a mad hunt trying to find it just before a hearing. And sometimes those documents can make a real difference to your case. They could be fatal, they could really support it. So it's just trying to make sure as best as you can, sometimes of course we can't avoid these things, but as best as you can, that you have all of the relevant documents, that you've seen them all. And if you think there are documents that plainly haven't been disclosed which are relevant, of course you can then always apply and consider applying for a specific disclosure, and indeed for third-party disclosure. In terms of witness statements, it goes without saying to check CPR Part 32 and Practice Direction 32 to ensure that any witness statement is compliant and, of course, contains absolutely what it needs to. It's surprising how often I find that witness statements don't actually comply. And it goes without saying, of course, just always make sure that the statement of truth is the correct one, because we still sometimes see the incorrect versions popping in occasionally, and you don't want to be met with an application about that. As you know, a witness statement has to have a comprehensive statement of facts. And I emphasise that word because there are still so many statements that I see that contain opinion evidence from lay witnesses or submissions or comments. It's not what they're designed for. I tend to find judges get really grumpy about it for obvious reasons, and often entirely disregard multiple sections of a witness statement if they contain opinion evidence. It particularly also in personal injury claims, what I also find tends to get on a judge's nerves is if witness statements say that there are multiple claimants, all are identical. There is no difference between them at all. A witness statement should be in a witness's own words rather than your own, so it does raise an eyebrow if they appear to be copied and pasted. You also don't want to have in court, of course, in the middle of a trial, where someone accepts that actually that witness statement isn't in their own words, they didn't write it, and because that can often be a bit of a telling sign that this is just something produced entirely by someone else and that they don't really know the contents of it. So that's what we're referring to when we're talking about the convincing authorial voice, coming from the witness's own words and in their own language. Equally, the judge isn't going to want to see a witness statement that's just excessively long for no real reason. Now, in terms of application witness statements, I appreciate we've been talking about lay witness statements, but in terms of application witness statements, remember that these shouldn't really be skeleton arguments. They seem to have now somehow taken on an ability to look like a skeleton argument, putting in all the relevant law and making submissions and the like on different points. But that, again, is not what they're designed to do. Leave a skeleton argument for a skeleton argument. Don't make a witness statement one. They should, however, set out a chronology of facts. I always find that really helpful, but just leave the submissions to the court and the court hearing. In terms of expert reports, again, go through CPR Part 35 and Practice Direction 35 with a fine-tooth comb. Paragraph 3 of Practice Direction 35 sets out what is specifically required in terms of the form and contents of an expert's report. I'm sure you all know about it, but it is surprising how many reports I see where the requirements within there are not met. So, for example, an expert needs to put the details of their qualifications in there, details of any literature or other material that's relied upon, a statement setting out the substance of the facts and instructions which are material to the opinions expressed, and it goes on. So I always, when I'm looking at an expert report and asked to have a look at it, I always get open Part 35 and Practice Direction 35 just to make sure that it does have everything it needs. Again, you want to avoid anyone saying this report is just simply not compliant. Remember also that there should be a distinction between what an expert is told and what their opinion is, and that should be clearly set out in their report. And it's also really helpful for them to comment on a range of possible views and then to state specifically why their opinion is what it is. And you'll see on the slide that the report, we say, should be comprehensible. And sometimes you get a report and it's just difficult to make head or tail of it. You have to remember that if you can't make head or tail of it, a judge isn't going to either. It has to be easy to understand, and the reasoning and logic has to be easy to follow through so that a judge can understand exactly how they've reached their conclusions. When talking about cases with a foreign element, so a travel law claim, for example, sometimes those reports are in another language, and that can be difficult when they're translated, or even when, in terms of collating the report together, because sometimes it's not entirely clear. You've got to make sure that it's broken down as possible so that a judge can follow it through to conclusion, and it makes it much easier for everyone to understand.
Oh, just on that, Dom, I just wanted to say, I got a report the other day, well, a couple of months ago probably, and it was about 80% acronyms. And I'm sure that made sense. I think it was an anaesthetologist, or can't remember who it was, medical professional anyway. It probably made sense to that medical professional. It did not make sense to me at all.
Yeah.
And after about 2 pages of translating acronyms with the benefit of Google, I kind of thought, the judge is just not going to do this. So went back to the solicitor and asked her to go back to the expert and say to them, look, can you just do exactly the same report, just explain the acronyms, and try not to use too many acronyms all the time, because it just becomes impossible to understand. You get that quite a lot in clinical negligence, I think. We've also got a question, Dom.
Oh yeah, let's have a look. In relation to witness statements, and specifically witness statements of a witness who can't speak English, what's best practice? Is it to have it taken in their language and then translate into English and signed by a translator? Or can it be taken in English, written by a translator, having been spoken to the translator in that language, and signed by both? Well, it should be in their own language first and then translated, and there should be an affidavit. And what I should say in respect of that is that again, look at the CPR, because what's in there tells you exactly what you need to show in terms of the affidavit and what it needs to state if a witness statement has been translated from a witness's own language into English, because sometimes that requirement is not met. And I find more and more actually that a translator will put their own declaration or just sign something to say they've translated it, but it doesn't quite comply with the CPR. So make sure that you look at the CPR and what is required if you are going to be translating it, but it should be in their own language first and then translated. Unless, so have you got anything to add to that?
I don't know exactly that. And I think you need to be quite careful with foreign language witnesses, because you sometimes see both witness statements and expert reports which are in English, and then the witness comes to court and either they are shaky with their English or they just don't speak a word of English at all. And that raises, that's just, easy 10 minutes of cross-examination on, when you signed this witness statement, you didn't understand it, did you? And the witness will say, well, it was read to me by the solicitor and the solicitor explained to me what it said, but it's just not good enough. And sometimes you see English statements which are then translated into the witness's language.
And they don't make sense, actually, I tend to find.
No.
I'll have a witness say, that's not what I mean at all, because what's said in English is not the equivalent of what they were trying to convey. And then it throws up a whole host of problems as to what they actually intended to mean and whether there's any inconsistencies or not. Yeah.
I mean, it's a recipe for really, really good cross-examination of the witness, saying, you just signed up to it and you'll sign anything, won't you? And then you just sit back exhausted. Yeah. So that's a really important point, actually, in relation to foreign language, both statements and reports.
Yes, definitely. And just going back to the expert reports, I know, Sarah, you were talking about acronyms, and sometimes I find with expert reports, what's really helpful is to just have a conference with the expert, because even sometimes when they explain what their acronyms mean, you don't really understand. If you haven't got a medical background, as many of us don't, you don't quite understand sometimes the reasoning behind how they get to their opinion or what they're really trying to say. Sometimes it's extremely complicated, particularly in clinical negligence claims, to work out what they're trying to say. And when you have that conference with them, you think, oh, okay, this makes so much more sense. I thought you meant this, actually you mean this, and there's a subtle difference. So if you can have a conference before, if there's anything you're a bit unsure of, I think it's always sensible. But I tend to advise one in any event, because again, just not having that medical knowledge in that level of detail, I think sometimes there can be occasions where we, as I say, may assume one thing and it's not quite right. And obviously in clinical negligence claims in particular, that sort of thing is really important. So I do think it's really helpful. We then put a slide up about case reviews, about when you should step back and review the case. There are always a number of points at which to do this. I tend to find disclosure is one of the first, because of course at that point you may be provided with documentation that either negatively impacts your client's position or supports it, or there may be something that comes out that's a bit of a surprise in the disclosure process. Likewise, with witness statements and expert reports, you may find that issues start to arise, and there's a continual process here of checking if new information that's coming out, or indeed if witness statements and the like are coming out and the other side is providing a bit more clarity on their position, does that impact the prospects? Are they weaker than you thought, or are they stronger? And that then ties into settlement and whether you decide at that point to make offers or not. But I tend to find that it's really helpful at these points, because particularly in cases where, and we know with clinical negligence cases and with personal injury cases, for example, consistency is key. And if you start getting information through, for example, if I have a claim notification form, particulars of claim, and the initial medical report come through, and I draft the particulars, so I've got all of that, I then I'm told about the disclosure process and medical records are provided, and that says an account that's completely different to what is said in the other documentation. Say, for example, medical records weren't reviewed by your GP expert, then there are issues that you need to address. You have to wonder why. Why is there now a change? You would hope that some of this information would be forthcoming beforehand. Indeed, there could be an accident report form or something that hadn't made its way to you pre-action, but then does, and it says something completely different. So you have to look at these things and reassess prospects to work out, should you continue to fight this or not? I can see there's it's a chat. Sorry, I thought there was a question coming through. In terms of CPR Part 18 questions and Part 35 questions, you may want to, in the course of litigation, ask either. I find they can be a double-edged sword. You might be able to win concessions in those questions and narrow the issues, but you could also cause an expert to double down on their opinion, or indeed you could signal your strategy to your opponent. I think you have to be careful whenever you're asking either Part 18 questions or Part 35 questions, and just not ask unnecessary questions, because you don't want to gain an answer that damages your case. It's a bit like when we cross-examine people, and we were always taught, don't ask a question that you don't know the answer to, because you don't want that to ultimately cause any problems if you're not sure of what's coming. In terms of Part 35 questions, I tend to find that there are so many questions that are put about a claimant's credibility, and the expert is not there to answer questions about whether someone's honest or credible. That's a matter for a judge. And so even if you think you've got a winning answer, if you're a defendant, where they say, well, this makes me think that I might question their credibility because they didn't tell me this. Well, actually, that's irrelevant, because it's a matter for the judge. It would make more of a difference if it was, does this change your opinion of causation, for example, but it doesn't really help when it deals with credibility. And so I tend to find you've got to be quite careful, and sometimes questions are asked which seem to delve into qualifications. Sometimes those can help. For example, you might find an expert report where an expert has clearly gone outside of their remit, talking about things that they're plainly not qualified to do, and you can ask questions to clarify the nature of their qualifications. But sometimes I feel points are made in Part 35s in particular that in terms of qualifications that actually don't gain helpful answers. So you just have to be a bit careful with what you're asking and think about the purpose of why you're asking that question. What do you actually want to achieve from it? How is that going to help your case? You could also think about notices to admit facts. I know that these are popular with Sarah. I tend to find I don't find in many of my cases actually that these are ever really agreed or utilised. But Sarah, in terms of your perspective, have you found them to be quite helpful?
Oh, I love a notice to admit facts, Dom. Yeah, because if the other side doesn't admit the facts, then you've just got free reign of spending as much money as you want on establishing the facts. So things like I'm thinking about local standard stuff. You know, the local standard is a fact, and you say, do you admit that it is a fact that the local standard is X? And then if the other side doesn't admit that as a fact, and you have to go to the expense of getting an expert report, you're on really solid ground that whatever happens with the claim, fact-based, you're going to get the cost of that expert report back. So you're kind of gold plating yourself. The other thing I really like is notice to admit facts on things like that the applicable regulations are the ones that were in place at a particular time. So as you know, it's, things like construction regulations are as at the time of construction. So when was the building constructed? Did these particular regulations apply to it? I love a notice to admit facts. And because the other side hardly ever admits them, because they don't think about them. So they won't make any concessions on them. And then you just toddle off and you get expert evidence, or you get a third party disclosure, for example, where you go to the third party and try and find out the facts. And then your opponent is going to have to pay for that because they haven't admitted the facts. So yeah, I love them. Not so nuts about Part 18 questions, but I know that Connor thinks they're great.
I know, I'm not so crazy about Part 18s. I think you have to be a bit careful. But what I also should say about Part 35s is remember the purpose of them. They're for clarification. And I tend to find, again, you might get 10 questions put to an expert, which actually are more of a sort of quasi cross-examination on paper, rather than actually clarifying a point that they've made. We've had 2 questions in, I should say, Sarah, that once witness evidence is exchanged and the expert changes their opinion on any part of the claimant's claim and potentially no longer believes the claimant, is there any way of saving the claim? I think that's difficult territory, isn't it, really?
Yeah, I mean, I've had claims where the expert said, oh, I don't believe them anymore. And I've said, well, it's not your job to believe them or not believe them. So what if you don't believe them? And I've been successful in that and had judges say, well, okay, the expert didn't believe them anymore, but I do. I've heard them give evidence and I believe them, and I'm not bound by the expert's view on credibility. So,
that comes back to the point, doesn't it, about credibility is not for an expert. And I think that's a point that's often confused. But yeah, I think it depends obviously what your experts now said as to why they don't believe them. If you need to do a bit more digging to find out actually has something gone seriously wrong here.
Yeah, for sure. Yeah, of course. I mean, if it's surveillance evidence and they're sort of trampolining with a broken ankle, then there's a good reason as to why the expert doesn't believe them. But generally speaking, experts should not be opining on credibility. And that's another one of my many bugbears.
Yeah, absolutely. Absolutely. And as we say, it's different. I had a case once where someone was claiming all manner of disabilities arising from an accident. And then we got surveillance evidence of them at Glastonbury on someone's shoulders and having a lovely time. But it's that sort of thing that's a bit different, I think. And what I would expect is not an expert to say, I no longer believe them, but just to say, I obviously gave X opinion on their injuries. This appears to be inconsistent because they're now moving said limb. Just what I mean, rather than saying, I think they're now a liar. But we've also had a question about if the other side asks a question of your expert and it's outside their area of expertise, is it for you to step in and say it shouldn't be answered, or should you leave it to the expert to do that?
And another question as well, which is similar, if a question is raised that you think is inappropriate, should you leave it to the expert and whether to answer it? I tend not to let them go to the expert, because quite often you get experts who they're showing willing, they want to answer questions. So I tend to just not to put them to the expert, or if I am going to put them to the expert, I say to them, look, you should not be answering questions 8, 12 and 13 because they go outside your area of expertise. So I tend not to leave it to the expert, because sometimes they attempt to answer questions they shouldn't be trying to answer.
Yeah, you just got to, that's why
sorry, Dom. We had another question on, does this apply? This is notice to admit facts. So obviously I'm keen to drag the discussion back to that. To Quox cases, it does apply to Quox cases. So what will happen is that if the claimant gets any damages at the end of the day, then the costs in relation to that fact, in relation to proving that fact, will come out of their damages. So it's quite a powerful tool if you're for a defendant. I mean, obviously don't deploy it all the time. I love notice to admit facts, but I don't ask that many of them. But it's just another thing that's out there, a little quirky thing that might help.
Absolutely. So turning, this is the last one for me before I hand back to you, Sarah, but in terms of settlement strategy, when should you consider it? All the time. All the time. I think we all know about the cost of litigation. We know about Quox. If you're for a defendant in a personal injury case, for example, unless you can prove fundamental dishonesty or get in one of the other Quox exceptions, chances are you're not going to get your costs back. So you need to be thinking about, is there an opportunity to settle sooner? I think often some parties don't want to settle or engage with settlement discussions at all, and that's their prerogative. It might come down to their client's instructions, but I think it's helpful to be considering it all along, particularly when you get into the realms of cost budgeting and the like. But please, we beg, please don't consider it for the first time 2 weeks before trial. You'll be paying far more than your clients will be paying far more at that point. And often I find they're not too happy about it, that it's sprung on them at the last moment, that they think, well, why now? Why have I run up all of these costs if we're now saying that we need to just get rid of the claim, for example? But I can see we've had a question. We often get questions to experts asking about their relationship with us, the solicitors. Is that appropriate in your opinion, or should you advise the expert not to answer it? And I can see, oh, Sarah, you've taken that off.
Sorry, I've taken it off because I'm quite keen to answer that.
Yes.
It's not clarificatory, is it?
No.
So it's not a Part 35 question. I think it's a really simple answer to that.
I think so.
The expert should not be answering that question.
Yeah. And that comes back to, well, again, we said the point earlier, remember the purpose of Part 35s. And I've had so many cases where Part 35s have been disputed and a judge has said, this is not a Part 35 question. This is really, none of these are Part 35 questions and don't really help at all. And again, even the points of credibility, that doesn't help me. So they're just sometimes wasted, and you don't want to waste time on that sort of thing. And unless you've got a good question that's actually going to help in terms of your claim, don't ask them just for the sake of it when they might be ones that don't add anything at all or just inappropriate. That's what I would say. So yes, in terms of settlement strategy, it's always worth considering it at every point rather than just at the tail end of the proceedings. So now back to you, Sarah, on recognition enforcement.
Yeah, I just want to say on settlements, in relation to settlement strategy, there are different strategies for different cases and for different types of case. So because I work in quite a niche field, which is cross-border stuff, and Dom, you work in fairly niche areas too. So Clyneg is fairly niche, although bigger than my area. You know your opponent. So you think about who's on the other side, which firm of solicitors, which barrister is on the other side. There are some firms of solicitors, I know there's no point talking to them about settlement because they're not going to do it.
Engage, yeah.
Yeah. There are other firms of solicitors who I know they'll run something hard or they'll settle it. And I can trust the firm on the other side to take a view on settlement when they're ready. There are other firms that need to be coaxed into thinking about settlement. And same with barristers. If I look at someone's name in a pleading or I'm against them in a hearing, then it might be worth me emailing that person and saying, look, we've got a really good relationship. I feel that we ought to be able to settle this. Let's have a counsel discussion. I mean, a really good example of that is something that I had, which was a really sad case, fatal accident case. And I was for the widow. And what she really wanted, and this comes back to what we were talking about earlier, what she really wanted was to understand why her husband had died. And she wanted some acknowledgement from the defendants that it had happened on their watch, and that it wasn't going to happen again. And I knew my opponent really well, and I knew that my opponent was willing to think about settlement in appropriate cases. And we managed to agree a settlement package which enabled her to feel that she had got what she wanted out of the litigation, and it enabled his client to get out of the litigation without spending too much on costs. So it was something, I wouldn't say that anyone was happy at the end of it, but it was the least bad result possible. She didn't have to go through a trial. They didn't have to go through a trial with all the attendant publicity. And they got rid of the claim at what was, not a bad settlement for them. But she felt that she'd been heard and that her aims had been satisfied. So I think that factors in on, who's on the other side. Do you need a mediator because the person on the other side is so difficult to deal with? Or can you use counsel as mediators? Sometimes firms fall out, but counsel don't. Sometimes counsel fall out. And actually, you might want to think about replacing your counsel, because if they're not getting the best out of the other side, maybe it's time for a shake-up. Think about somebody else. Not me, obviously. That would never happen to me. So recognition enforcement. Again, we're saying from the beginning, consider everything from the beginning, but think about recognition enforcement from the beginning. There's no point getting a judgment, and a lovely big cost judgment, if you can't enforce it. So you need to think about whether or not this particular defendant is going to be able to satisfy a judgment. There's no point doing it and putting the client through it and running up costs if you can't get them back. If you've got a cross-border case, you need to think about recognition from the beginning, because if, for example, you have got a Russian domiciled defendant, are the Russian courts going to recognize an English judgment? If they are going to recognize an English judgment, are they going to allow enforcement in Russia where the defendant's assets are? Or does the defendant maybe have some assets within England and Wales that you can enforce against? So these are the kind of things that you're going to need to think about in relation to cases with a foreign element to it. Now, in relation to recognition, well, in relation to both actually, everything's changed since Brexit. So previously within Europe, the European courts were recognising and enforcing English judgments without any difficulty at all. Well, without much difficulty in some cases. Now everything's changed and we are falling back in relation to recognition. So the foreign courts accepting English judgments as if they were their own on treaties from the 1920 and 1933. So in terms of recognition, you're looking at bilateral treaties. You're not looking at Recast Brussels anymore. So Dom, can I have the next slide? There we are. It's all about the bilateral treaties now. You need to take advice from an agent. If your defendant is located abroad, you need to take advice from an agent who is also located in that place. What are the logistics here? Your agent may well say to you, well, as a matter of formality, Russia will recognise English judgments. But if it takes 10 years for Russia to recognise English judgments, and if then there are curbs on the extent to which they'll allow enforcement, there's just no point bringing that claim unless it's an enormous claim and the client's happy to wait for a decade. So explore the logistics. Now, I've said remember Greece because although prior to Brexit, European courts were supposed to recognise and enforce English judgments, the Greek courts did not do that, in fact. So even before Brexit, the Greek courts were refusing to recognise and enforce English judgments on costs because they said they were contrary to public policy. So you need to think about those aspects of it as well. Could there be reasons why that foreign court might refuse to recognise an English judgment? There's a really interesting question about whether or not the English judgment needs to be a High Court judgment or can be a county court judgment. Under the treaties signed under the 1920 Act, it has to be a High Court judgment. Under the 1933 Act, there is a possibility that it might be a county court judgment, but it is then certified and then sent over to the foreign courts. The Queen's Bench Division guidance provides that you should be issuing out of the High Court if you think you're going to have to enforce abroad because of this issue. Whether or not it is sufficient to get a county court judgment and then transfer to the High Court for certification is an open question. But I can say certainly the courts of Jersey will not recognise an English judgment of a county court. So if you think you're going to be enforcing in Jersey, you need to issue in the High Court and get it set up from the beginning. Otherwise, you could go through the whole thing in the County Court, certify in the High Court, go to Jersey to try and enforce, and you can't do it. So really, really important. And the part that's relevant in relation to recognition is CPR 74. Now, enforcement is CPR 70, which is really great because it sets out a list of how to enforce your judgments. The first thing, of course, you want to do is get a cooperative defendant. So if the defendant is offering you a sum in settlement of your judgment figure, think about taking it, because otherwise you're going to have to expend costs and time enforcing abroad, which is difficult. Where are the defendant's assets? Can you enforce against those assets? If they're within the courts of, or if they're within the jurisdiction of England and Wales, you could enforce in a CPR 70 way. So the ways that we know about, things like third-party debt orders, where you seize a debt which is owed to them, so bank accounts, most obvious one. Charging orders over land, attachment of earnings, you might be looking at committal or sequestration within this jurisdiction. If the assets are all abroad, then you're going to need to take advice from an agent again, because it's the enforcement of that judgment is going to be governed by those foreign rules abroad. It can be a very, very long process, and it can be enormously expensive and with no recovery of costs. So this is why you need to think about it very, very early on, because even if you're looking at a defendant which has assets, if those assets are abroad exclusively and there isn't anything within England and Wales, then you need to factor in that as a potential difficulty if the defendant's not cooperative in looking at whether or not it's economical to bring the claim. It's possible the defendant might dissipate assets. You need to think about guarding against it doing so. But if those assets are abroad, again, it's a real difficulty. And actually, if you've got a defendant that's likely to dissipate assets, in most cases, that's a real problem and actually militates bringing in the claim at all. That's all I wanted to say about enforcement. So any questions on recognition and enforcement? Well, any questions on anything?
Yeah.
You're very welcome to. I'm sorry, we've run 1 minute over time, which is very unlike me. Usually it's about 20 minutes over time.
I was going to say we did very well actually for only 1 minute over. But yeah, if you have any questions at all, feel free to pop them on the Q&A now. If not, you've got our email addresses. Feel free to drop us an email at any time, and we'll be happy to help.
I have to say, Dom, I did have my doubts as to whether or not we were going to be able to fit all aspects of case management into an hour.
We just about did it.
We've not done badly.
Yeah, whistle stop tour for sure. But I can't see. Oh, we've got something in the chat, but
no, just grateful. Thanks.
I can't see any questions that have come through, so I'll take that everyone has had their fill of how to improve the case and get the most out of it. So I think I'll draw it to a close. But thank you so much for you all attending. It's been lovely to speak to you. And again, as I said, if you want to get in touch with us, please feel free.